Now, this week, we saw the much awaited 100 days in office of President Bola Ahmed Tinubu. Now, in the course of that 100 days, the president traveled to India for the G20 summit. But on the sidelines of the summit, the president met with several investors who, as he looked to bring in more foreign direct investments into Nigeria. But whilst he was in India, we also saw how the Presidential Election Petitions Tribunal, gave its judgment on the petitions of the opposition parties. Thanks for joining us. This is Standpoint. I am Precious Amayo. Now, the 100 days of the president was overclouded, if we put it that way, by the Presidential Election Petitions Tribunal judgment. It was September 6th, and both of them fell on the same day, and that was what everyone talked about. But it was also, as it were, a gift for the president, as that ruling was in his favor and that of his party. The Presidential Election Petitions Court delivered a 12-hour marathon judgment on Wednesday, throwing out the petitions of the Allied People's Movement, that's the APM, the petitions of the People's Democratic Party, PDP, and its flag bearer, Atiku Abubakar, as well as the petitions of the Labour Party and its presidential candidate, Peter Obi. The tribunal dismissed the petitions of the three parties challenging the victory of President Bola Ahmed Tinubu of the All Progressives Congress in the February the 25th poll. The five-man panel led by Justice Haruna Samani not only dismissed the consolidated petitions of the PDP, the APM, and the Labour Party, but it also clearly confirmed the victory of President Tinubu, who is also a former governor of Lagos, in the presidential poll. But as we know it, mixed reactions have continued to trail that particular judgment. The Labour Party and the PDP have rejected the judgment of the tribunal and say they are heading to the Supreme Court. We've also seen lawyers argue on some of the judgments and provisions, by the tribunal or by the judges. Let's bring in our guests now. We have Kennedy Osunwa, who is a lawyer, joining us via Zoom from Owerri. We also have Liborous Oshoma, who is also a lawyer, joining us via Zoom here in Lagos. Good to have you join us. Well, let me begin with you, Liborous Oshoma. We've seen both the opposition candidates, the Labour Party and the PDP, saying that, look, they think that this particular judgment is bereft of justice and they're heading to the Supreme Court. Let me get your overall thoughts on that judgment.
Yeah, thank you. The first question I would want to ask, without sounding patronizing, is when the judgment of the Supreme Court in Osun was delivered, these same people, the first statement I want to make, these same people who are saying that this judgment is bereft of reasoning today celebrated that Supreme Court judgment in Osun. So what is the difference with this Supreme Court judgment and this Court of Appeal judgment? The difference is that the parties have changed. The shoe is on the other foot. And so that is how lawyers sound when judgment is not in their favor, especially considering the fact that you have an election that was built and banked on sentiments, a lot of sentiment. It was as if some politicians came from the moon, while others were from out of this planet. It was as if we're not talking about Nigerians. And so I understand the sentiments expressed by people, including some lawyers who you would expect would discuss law, but will be discussing sentiments. I understand all of that, but I would say, unfortunately, election cases are not proved based on sentiment. Election cases are proved based on law. In the same vein, while we're saying all of this, the same a court gave judgment to Natasha Akpoti in Kogi because she proved numbers. Election is about numbers and not about sentiment and not about pandering. So if you say, like they say, he who alleges must prove. And so if you say that you scored 200 votes in a polling unit, but that what was recorded for you was 20. You must prove through documentary evidence and through eyewitness account the fact that truly, indeed, this polling unit, this was actually your score. And it must be people who were there and the documents that emanated from there. And they are time-bound. So you don't have to. In proving irregularity, you don't have to file petition and then now go fishing for evidence to support your claim. All of those subsequent evidence will not be relied on. So unfortunately, the country has been, heavily, weighed down, and sentiment had taken the space of law. And I quite understand because when, with the advent of social media, everybody becomes a lawyer, it is difficult for you now to distinguish between law and between the lawyers and the laymen. So that's why you hear all of this. So lawyers ordinarily always go on appeal, they condemn judgment when it's not in their favor, but when it's in their favor, they tell you it is victory for democracy. And so I'm not surprised. You certainly hear discordant too from both sides.
But they say that, or they are alleging that this particular judgment was skewed against them from the very beginning. That, where does that leave you, according to them, when you have 13 witnesses and 10 of them, as it were, are disqualified, only left with about 3, and that it was, as it were, skewed against them from the beginning. In what case, in what situation do you have where, it just says you have 13 witnesses and disqualifying 10? What happens in that particular situation?
Look, it is, like I said, this has no foundation in sentiment. If you have a case to prove in court, you know how to go about it. The first thing is, what is my evidence? You collect your evidence. The second thing is, who is presenting the evidence? Are these people that, we pass the test of the procedure for presentation of evidence? The third thing is, this, how is this proof required? What is the time that I have to do all of this? By the time you fail all of these texts, the court will not say, because you have been crying, that, oh, look, this thing is skewed against me. And so because of that, they will look at you and say, because you've been crying, let us give you judgment. Like I said, in the moment a result is announced in election, the law presumes it's in the presumption of regularity. The law presumes it regular. It is you that is saying that election is skewed that will now begin to prove irregularity bit by bit, and it must follow procedures. And once you file your processes, there is no time for you to begin to amend them. And the law also says once you file your petition, the witness you are going to rely on, you must list them, and you must also file what we call witness deposition that they are going to rely on, and the documents that they are going to rely on. Unlike in civil cases where you can amend, in election petition, you cannot amend. The law is very strict. So I do not know when somebody says you file a petition, you attach only 3 witness statements on oath, knowing fully whether every subsequent witness you bring outside the required 21 days, that is going to be discountenanced by the court. Only for you to turn around and say, this petition was skewed against, this proceedings was skewed against me right from the beginning. Because you intentionally knew fully well the requirement for proving your case, but you didn't do it. If these same people that are complaining, like I said, they had a case, they were on the side of the respondent in Osun, it was easy for them because the onus was now on the petitioner in Osun to disprove, which was difficult. And since the petitioner couldn't prove, court gave them judgment. Now the onus is on them as petitioner also to disprove. Since they couldn't also prove, court has given them the other side judgment. So it's that simple.
And they've also talked about how this particular judgment was based on technicalities and not necessarily on the law. And I'd like you to react to that.
I have listened. Look, I have taken time between yesterday and today to read the entire gamut of that 780-something pages of the document. I read it again, apart from listening to it. And I had cause to argue with a colleague not too long ago who was saying that he raised some technical grounds. And I referred him to the body of the judgment. He said, take, for example, the woman that who claimed to be an expert witness working for Amazon. that her witness was discountenanced, but unfortunately, the witness statement of the testimony was discountenanced, but that the ground that she's a party member, but that the testimony of Okpeyemi was accepted, even though he's a party member. And I said, no, go back and read page 473 to page 478 of that body of that judgment, and you will see that a statement was not discountenanced on the fact that she was a party member. A statement was discountenanced because she came in even though she's a party member, she came in as an expert to speak to a document she did not produce. And having not produced that document, the court said you have no competence to speak to that document. And that was what she came to do. And then on the issue of, if you still go down, further down, that same page 473 to 478, the court also said on the issue of double nomination, because people are saying, oh, the court said that double nomination, that it is not Shetima's fault. The court didn't say that. The court said that Supreme Court haven't decided that case, haven't made robust pronouncement on the position of double nomination in the matter between PDP and INEC, that the court was no longer competent. It was now stopped to make a pronouncement on it. On the issue of, qualification, the court also talked about Section 137 on the requirement for contesting for the office of president. And that for you to contest for office, you must either be convicted. And the court said a forfeiture does not amount to conviction. Where you forfeit assets, forfeit money, that it does not amount to conviction. Unfortunately, let us even tell ourselves the truth. In 2003, Obasanjo attempted to disqualify Atiku Abubakar, the same Atiku Abubakar, using a panel of inquiry set up by the government, indicted Atiku. And that same panel, on the ground of that same panel, Boris, who was China chairman, attempted to disqualify Atiku. Atiku approached the court. Justice Numido Akonde heard that Atiku cannot be disqualified on the basis of a panel of inquiry because that panel of inquiry was not a court of competent jurisdiction. And the Supreme Court also so heard. At that time, it was victory for democracy. It was not technicality. But today, the same court is saying that the same court is saying that a forfeiture of money does not mean an indictment, a term of prison that would warrant somebody who was not charged, who was not tried, who was not convicted, that would warrant a court to say you have been convicted. And you say, no, it is technicality. So these are the issues. On the issue of IRED, quickly, the court simply followed the dictum and the Supreme Court decision in Osun and in Adeleke and Gbega. So the Supreme Court had ruled on that copiously and said Section 60 gives INEC wide discretion. So until you amend that Section 60, there is nothing the court can do. It says INEC is at discretion to use any manner they deem fit to transmit results. INEC also now says, yes, we gave you guidelines. In their own testimony, we gave you guidelines. But in the course of the election, we had a force majeure. We also know that force majeure also in law, even in contract, frustrates it's a plea of frustration of a contract. And so if that be the case, INEC simply said, we had a force majeure. We had a glitch. It is for you. The lady you brought to prove that there was no glitch, at the end of the day, could not establish the fact that there was no glitch because the document she also sought to tender did not emanate from her. So all of these are the issues. For me, as a lawyer, also as somebody who is practicing law, who has practiced both civil, criminal, and electoral petition matter, that is why I do not dabble into filing cases for petitioner because it is a tall order and a very difficult one to prove at that matter.
All right, so let me bring in Kennedy Osunwa, who is joining us from Owerri via Zoom as well. And I also want to get your thoughts, Mr. Osunwa, on this judgment. What's your reaction?
Well, my position on the Presidential Election Tribunal judgment is a judgment that has been delivered pursuant to evaluation of concrete evidence before the court and matched with facts, giving facts which the learned judges looked upon
Mr. Kennedy Osunwa, please go on if you're still there. All right, seems to be having network challenges. Okay, all right, go ahead.
Just as my brother did mention, courtroom business is quite different from the business in marketplace or the business in party. Courtroom business is a very special and a very serious business that if you are coming into the court, you must be guided with the principles guiding the operations of the courtroom business. And that is why the opinion of the media campaign is quite different from what obtains in court. Now, if you are challenging the presidential election, it must be based on facts, not on sentiment. Because if you base it on sentiment, you will not be able to prove what has happened and why you feel that President Tinubu was not unanimously elected as the President of the Federal Republic of Nigeria. So it is a different kettle of fish. The lawyers know I commend them, but then they know also that what they are in for is a question of imperative evidence. You need to lead evidence to ensure that the facts you are presenting before the tribunal is concrete in the sense that it is going to bottle or water down your position that the election was mad one way or the other. But outside empirical evidence of the issues raised, I think there is no case with any of them to justify that the judgment is one way or the other, not what it ought to be. I commend the judges of the election tribunal.
Well, I was asking Mr. Liborous Oshoma earlier, for those who are alleging that, look, some lawyers who were saying that the judgment was based on technicalities and not on the law. I just also want to get your reaction to that.
Well, as far as I'm concerned, I've listened from both sides. And like I was discussing with somebody yesterday concerning the judgment, everything that you feel that it is based on technicality, the issues that is based on the technicalities, just like my brother has enunciated also, the same thing has been precedent that has been tested. Remember that as far as law is concerned, law is the prophecy of what the court says that law is. And there are hierarchical structure in judicial system or in the court system. Now, just like my brother said, this same thing has happened in Osun. Nobody complained. This same thing. Also, the Supreme Court has upheld that in issues like this, Section 60 also give the INEC a wide range of discretion to conduct the election, and that the INEC has come out to say, well, I did not use the machines because these machines are not properly giving us what we want. And that is what they decided to do otherwise. And that is what the law is saying in that omnibus section. So as far as I'm concerned, I do not see or envisage any form of technicalities in that judgment. In as much as the case that was before the tribunal, the evidence before the tribunal, the facts before the tribunal, that is what the tribunal has evaluated to arrive at the decisions that is enshrined in that judgment. That is the order of today. Those section 285, particularly subsection 7, has given the aggrieved the opportunity to ventilate whatever they feel it is not in tandem with the tenets of justice. They can approach the upper room, the Supreme Court of Nigeria, and then let us also hear how the Supreme Court, or see how the Supreme Court will also evaluate their issues, so long as they play by the rules of not bringing in or introducing new issues. If it is the issues that has been ventilated upon, then suffice it to state that the Supreme Court, if they are, of course, I know that the parties, some of the parties, has equally approached the Supreme Court that same day or the following day. So thank God for this window. They can explore it, and then let us also hear the view of the Supreme Court. But I assure you, from what is on ground, I don't see the decision, I don't see the Supreme Court giving decision that is very different from the ratio that the tribunal has looked upon to give the judgment. Mind you, when you look at that judgment very well, you will.
Right, Mr. Osunwa, your network seems to be breaking there, but let me bring in Mr. Liborous Oshoma into the conversation. What a lot of people cannot wrap their head around is the fact that the tribunal resolved all the issues in favor of the respondent. How do you respond to that? And just explain that to us, how that happens. Mr. Liborous Oshoma.
Hello?
Yeah, okay. Well, I didn't know. I thought it was my colleague Osunwa that you were asking. The issues, like I have told you, let me break it down for the everyday man to understand, even though the tribunal, tried so much to use everyday language so that people that are discerning will follow. What the tribunal simply did was, first and foremost, you said, the petition said elections were marred with irregularities and that you won the election. And so that you won the election and you have documents to prove, and that you're going to show videos, and that you're going to bring documents to show that you won the election, that the election was marred with irregularity. And then, secondly, the Peter Obi's petition, though, did not challenge the educational qualification of the APC candidate, but they challenged double nomination. They also challenged the issue of forfeiture of $460,000. And then what the tribunal, the Peter Obi article, on the other hand, also claimed that they won. Then Peter Obi talked about Abuja 25%, that not having won 25% in Abuja ought not to have been declared, and that at best, the election would have been declared inconclusive. So article the same thing, claiming that he won also, an article also claiming a qualification, double nomination, and the FCT, and then the forfeiture. The first and foremost, what the tribunal simply did was, tribunal looked at both petition and the respondents' answers and said, okay, the witnesses, there were preliminary objections raised by the respondent that, look, this witnesses' statement cannot go in because they were filed outside the 21 days. The tribunal looked at them and said, oh, for the Peter Obi's petition, 10 witness statements were filed outside 21 days. And so to that extent, they did not meet the requirement of the law. Also, the fact that the law says that this petition shall be filed with witness deposition and document to be relied on. The tribunal, funny enough, the tribunal now quoted the dictum or the forward written by PDP's lawyer to say, this is your own statement. You said that every election petition must be accompanied by witness statement and document to be relied on. A failure to do so is fatal. We believe you, but you can't come and argue the opposite here. So having looked at that, they now also went further to say, okay, these witnesses that are coming to testify, okay, yes, you say their witness statements were filed out of time. The expert witness, are you truly coming as an expert? If you are coming as an expert, which document are you coming to tender? This document was made by somebody else. You cannot be cross-examined. It is an elementary principle of law that you cannot be cross-examined on the document you did not make. And you're coming, and that document also do not speak to the general issues, especially when the document is disputed. And the court said, not having made that document, you cannot come and then you came after the petition was filed. You can't be a subpoena witness because you were available to the party all of this while. So why didn't they make you a witness? Why did they wait after 21 days? They are now bringing you. That is overreaching the other party. So you cannot. For those that do not know, say, oh, the court used sentiment. Then on the issue of the, the AU and EU report, when we know, Kenneth Osunwa also as a lawyer knows, we both had the same former boss. All of these are elementary law that we know. The maker, if you are talking about a report, that you want to rely on the report that can be cross-examined, the maker of that report must be the one to tender the report. It is not a public document that you say, okay, a CTC will suffice. It is, they say you made a report. You are bringing the report without bringing the maker that can be cross-examined. And the court said, well, you not being the maker of this document, you can't tender it. You can't even be cross-examined on it. Everything, you can't just come and dump document on us. What would be the probative value of the evidence that we're going to attach to it? So we cannot accept it. The court also now looked at the issue of Abuja and said, looking at section 299 of the 1999 Constitution, it says, for the purpose of this Constitution, the FCT shall be regarded as a state. And to that extent, the National Assembly and the President shall make laws for the President, for the states, for the FCT, and administrative decisions shall be taken by the President. So, but in the event that you are interpreting this Constitution, you shall interpret it to be a state. It didn't say, the law, the Constitution didn't now say, oh, because it didn't have a governor or because it doesn't have House of Assembly, it is not a state. Because you say if you are interpreting this law, excuse me, you shall take it as a state. And so to that extent, the court said, that is what the Constitution says. And then the court now went further to say, there are no special votes. If you say FCT has special votes, are you now saying that if somebody won 100% in 36 states of the Federation without winning 25% in Abuja, that person cannot be declared as winner of an election? That is not the intent of the drafters of the Constitution. And then the court, like I said, also look at the issue of double nomination. Being a court of appeal, and my brother Kenneth has said, a court of appeal is lower in rank to a Supreme Court. A court of appeal cannot sit down on appeal or relitigate a matter where the Supreme Court has made a pronouncement on the position of things, especially when it concerns the parties. And they said, well, on this issue of double nomination, they quoted the dictum of Okoro and the dictum of, what's the name of this other judge, and said these people had chewed on this issue, brought out the nomination date, and that resignation took effect from the provision of the Constitution the day the man who was nominated as a senator tendered his resignation to his party, and that the party had a window of 90 days within which to forward a request to the national to INEC. That it is not when the party forward a request to INEC that resignation took place, but when the person who is involved tendered a resignation to his party, and that this member was nominated as running mate 4 days after he tendered his resignation as a candidate of the senatorial candidate to his party. The Supreme Court had dealt with that, and that was what the position of the Supreme Court. And so, to that extent, we cannot say that this man there was double nomination. On the issue of IREV, Supreme Court, the court said, well, we don't make law. Our own is to interpret the law. If Section 60 says INEC in transmitting election results shall have recourse to Form EC8A, and that Form EC8A, if you are not able to transmit it electronically, it shall be at the once it has been signed and distributed, the transmission shall be as recommended by INEC. INEC in its guideline recommended electronic transmission. And the same INEC, it is not another person now. If it is a different institution, that is where you now say, no, a different institution cannot come to say that INEC has made a recommendation. That institution or NCC or DSS or the police now say, no, INEC must not. Once that happens, that is when you say that INEC guideline had been violated by another institution. But in this case, it is the same INEC that came and said, well, the requirement we made, we said we will transmit electronically. We are not able to transmit electronically. We have accredited. The law says you must accredit with a device, an electronic device. But we cannot transmit because we have force majeure. So we are going to use another method. Do you know that throughout the entire gamut of the proceedings, you say the parties claim that they have witnesses and they have, what do you call it, a polling unit agent across the 175,000 polling, 176,000 polling units. Not one person from either of the polling units was called by any of the party to say, come on, not one agent at all. And so the court said, failure to call agents means that if you call them, that is the presumption against you. That failure to call them means that if you call them, the evidence I'm going to give will be against you. That is why you didn't call them, even though you said you were going to call them. Secondly, the document and the video you said you were going to provide. Failure to provide them is a presumption of law also that if you provide them, they will be against you. That was why you did not provide them. All of these were dealt with
Mr. Liborous Oshoma,
I
had to give you that time to explain in very plain terms, like you've done, these judgments and as to why all of the issues were resolved in favor of the respondents. You have done that successfully, explaining them, in very plain terms. But I want us to go on the break now. When we return, because you touched on electronic voting process, we're going to look at the Electoral Act and that particular electronic voting process, the implication of it, just after the break. And we still have Kennedy Osunwa with us. We'll take the conversation to him when we return. Stay with us.